Welcome to Lawyers Library, your guide to landmark judgments shaping India's legal landscape. Today, we delve into a recent and significant decision by the Supreme Court of India in the case of Sohom Shipping versus New India Assurance. This case, decided on 7 April 2025 and reported as 2025 INSC 453, revolves around the interpretation of a special condition in a marine insurance policy and the principles of good faith in insurance contracts. The bench comprising Justices B.V. Nagratna and Satish Chandra Sharma delivered this crucial judgment. Let's break down the facts of the case. Sohom Shipping, the appellant, purchased a barge named Srijoy II for its shipping business and planned its maiden voyage from Mumbai to Kolkata. They obtained a single voyage permit and an insurance policy from New India Assurance, the respondent, covering the period of 16th May to 15th June 2013. The insurance contract contained a crucial special condition: the voyage had to commence and complete before the monsoon set in. It also included a warranty that the vessel would depart in weather conditions not exceeding Beaufort Scale No. 4. The voyage commenced on 6 June 2013. Tragically, the barge ran aground near Ratnagiri port the very next day due to bad weather and engine failure. Sohom Shipping claimed total loss and issued a notice of abandonment on 25 July 2013. New India Assurance repudiated the claim on 12 September 2013, citing a breach of the special condition, arguing that the voyage started after the monsoon had begun on 1 June, according to a circular issued by the Director General of Shipping. The National Consumer Disputes Redressal Commission sided with the insurance company, dismissing Sohom Shipping's complaint, citing a breach of Uberrima fides the principle of utmost good faith due to the alleged suppression of material facts. This led Sohom Shipping to appeal to the Supreme Court. The Supreme Court framed the following key issues for consideration: whether the special condition regarding the monsoon was breached, justifying the repudiation; whether the special condition was ambiguous, warranting the application of the contra profrintim rule, interpreting ambiguity against the insurer; whether the special condition was material and a condition precedent to the insurance contract's validity. Sohom Shipping argued that the NCDRC's dismissal was legally flawed. They contended that the insurance policy's period itself, 16th May to 15th June, overlapped with the monsoon, implying a waiver of the special condition by the insurer. They further argued that the special condition was non-material and ambiguous, thus requiring the contra profrintim rule to be applied against New India Assurance. The appellant also claimed that the insurer failed to conduct proper due diligence, knowing the voyage would occur during potentially adverse weather. Finally, they argued that treating the condition as a condition precedent would lead to absurd outcomes, making claims impossible even if a peril occurred during a timely voyage. New India Assurance defended the NCDRC's order, asserting that Sohom Shipping clearly breached the special condition by sailing after 1 June and also violated another clause by sailing in waves exceeding 2 meters. They argued that the special condition was unambiguous, thus negating the application of contra profrintim. The insurer also alleged that Sohom Shipping suppressed their intention to sail during foul weather, breaching the principle of Uberrima fides, and even raised allegations of forgery regarding the policy documents submitted to authorities. After careful consideration, the Supreme Court allowed the appeal, setting aside the NCDRC's order and remanding the case back to the NCDRC to determine the insured sum payable. The Supreme Court's key findings were as follows. Interpretation of special condition. The court found the phrase, "before monsoon sets in," to be clear, referring to the DGS circular's dates, 1 June for the West Coast. Therefore, no ambiguity existed in the clause itself, and contra profrintim did not apply. Materiality and waiver. Crucially, the Supreme Court held that the special condition was non-material and impliedly waived. The fact that the policy covered a period overlapping with the monsoon, coupled with the insurer's knowledge of the voyage's purpose and route, made strict compliance practically impossible. Enforcing the condition strictly would lead to absurd results, defeating the very purpose of the insurance. Oberrima Fides, utmost good faith. The court found that Sohom Shipping had disclosed the voyage's purpose in the proposal form, negating the claim of suppression. The insurer's assumption that the vessel would be laid up during the monsoon was deemed unreasonable given the policy's terms. Other claims, the court did not delve into the allegations of forgery and breaches of other conditions, leaving these to be examined by the NCDRC on remand. The core principles established by the Supreme Court in this case are: insurance contracts require utmost good faith, but their terms must be interpreted strictly. A non-material condition that is impossible to fulfill or leads to absurd outcomes is considered impliedly waived and cannot be the basis for repudiation. The contra pro frontem rule applies only to genuine ambiguities within the policy wording, not ambiguities arising from external factors. Repudiation based on a breach of a non-material condition, the impracticality of which was known to the insurer at the time of the contract, is invalid. This judgment is significant as it clarifies the interpretation of conditions in insurance contracts, emphasizing that insurers cannot rely on technically breached conditions that were practically impossible to adhere to or would defeat the purpose of the insurance itself, especially when they were aware of the relevant circumstances. It reinforces the limitations of the contra pro frontem rule and underscores the importance of considering the commercial sense and purpose of the insurance contract. Ultimately, the Supreme Court allowed Sohom Shipping's appeal, set aside the NCDRC's order, and remanded the case to the NCDRC to determine the insured sum payable. The parties were directed to appear before the NCDRC on 29 April 2025 for expedited proceedings and were asked to bear their own costs. This case serves as a crucial reminder of the balance between the principle of Oberrima Fides and the need for insurance contracts to be commercially sensible and effective.